Good evening, Kathleen Drew, Chair of the Energy Facility Site Evaluation Council, calling our Whistling Ridge Energy Project Amendment request hearing into order for the extension request. We'll go ahead and have Ms. Grantham call the roll of council members.
Certainly. Department of Commerce.
Elizabeth Osborne, present.
Department of Ecology. Department of Fish and Wildlife.
Mike Livingston, present.
Department of Natural Resources.
Lenny Young, present.
Utilities and Transportation Commission.
Stacy Brewster, present.
Chair, that is all of the council. Would you like me to call any other roll or just the council?
Just the council. Thank you.
There's a quorum.
Thank you. We will now move to the Whistling Ridge Energy LLC presentation. Mr. McMahon.
Thank you, Chair Drew. For the record, Tim McMahon, and I'm here representing the applicant, I guess it's still called the applicant, TCT. It's not surprising that we've heard some concerns from the community. Concerns is probably not putting it strongly. And I want to just emphasize what we've said in the filings that we've made to the council. And that is that, first of all, we do believe that at the time we started meeting with FSEC staff, that the application and the site certificate, in fact, were still very much viable, and in our view, for the reasons I'm going to talk about, are still viable. We also understand that for us to proceed further, we've got a lot of work to do. And in fact, that's the reason for this request, is for us to have the opportunity to conduct some diligence work to really make a strong decision, well-informed decision, and the kind of information, frankly, that the public is providing is some of that input. So some very strong inputs on what our next step should be for the project. So fundamentally, what we've asked for is time, a relatively short amount of time to conduct studies and to determine where we should go and what we should do next. But I do want to emphasize that in our view, at the time that we started working on on this amendment, it was done in tandem and very much in consultation with FSEC staff, with the understanding that we were seeking time to conduct this work. So let me just kind of walk through the presentation here, and I hope to provide some information about the kind of work that TCT intends to conduct during what we hope to be a 3-year extension of the site certificate. So first of all, Whistling Ridge is not proposing any changes to the facility. There is no new information or changed conditions that might indicate the existence of any probable significant adverse environmental impacts that were not previously addressed in the FSEC environmental impact statement, which was conducted for this project and was appealed to the Washington State Supreme Court and resulted in a 9-0 decision by the Washington State Supreme Court. So we are not relitigating the Supreme Court's decision, nor are we relitigating the decision of the Ninth Circuit Court of Appeals that was filed and unsuccessfully filed by the Friends of the Gorge. So Whistling Ridge is not proposing any changes, modifications, or amendments to the site certificate agreement or any regulatory permits. It is possible that such changes could be proposed in the future. So I want to walk through the project history to explain really why we're here and what's happened, because there have been reasonable questions about what have we been doing and has this project been abandoned. Could you please skip to slide number 18? Yeah, keep going. That's 10. Oh yeah, sorry, we're keep going. These are page numbers from the environmental impact statement. Okay, one more, please. All right. All right. So this is the history of the project, and many have asked why we're doing what we're doing. So I want to just walk through this. The site certificate application, as indicated by members of the public, was in 3/10 of 09. The site certificate agreement recommendation was submitted to the governor in January 5th of 2012. And the governor signed and approved the final order in March of 12. After appeal by by opposition, the Washington State Supreme Court issued a unanimous decision denying the appeal. Now, Mr. Spadero, who was the project manager and with SDS Lumber, signed the site certificate in November 18, 2013, a few months after the decision by the Supreme Court. And the reason for that decision was knowledge that we had already undergone considerable amount of litigation on the project, and a concern that by signing the application on the day the governor signed the application was essentially inviting additional appeals and litigation. And Jason Spadero decided to, before signing the site certificate agreement, to take the time to see if any further appeals or litigation occurred. He believed there was not such an outcome, although that was proven to be wrong later on. So from 2013 to 2015, during that period, Bonneville worked on the final environmental impact statement and its supplement. This was a combined NEPA and SEPA document working with Bonneville. If you go to the next slide, please. So in September 2015, the project opponents in fact did file another appeal with the United States Ninth Circuit Court of Appeals that challenged Bonneville's final environmental impact statement, which was done in coordination with the Washington State SEPA environmental impact statement. So the appeal was over project interconnection to the federal transmission system. The Ninth Circuit Court issued a memorandum decision denying the appeal. So the Supreme Court denied the appeal. In 2018, the Ninth Circuit Court of Appeals denied the appeal. So in July of 2018, following that petition by project opponents for a rehearing, the full Ninth Circuit then, on request or require or demand from Friends of the Gorge and others, denied additional rehearing. And that denial finally in 2018 concluded all of the opposition litigation. So in October of 18, Whistling Ridge then filed its 5-year report, came to Olympia, met the siting council, and the 5-year report is really part of the project process to ensure that the siting council understands that a project is still proceeding, and the report was filed. So if you could go to the next slide, please. At that 5-year hearing, a presentation was made to the siting council, and at that proceeding, we confirmed our understanding of the effective date of the site certificate, which was after, which was as I indicated before. Just want to make sure I'm getting this right and absolutely correct here. Yes, it confirmed our understanding of the effective date of the site certificate, which I'll get to in a few moments here. So in 2021, SDS Lumber, the parent company, as many of you know, underwent protracted internal conflict, ultimately resulting in the dissolution of SDS Lumber Company and related entities. And in 21 to 22, Twin Creeks Timber, and you've met Mr. Corbin here tonight, acquired a substantial portion of the assets, including the Whistling Ridge Energy LLC, and it is still called Whistling Ridge LLC by virtue of transfer of the LLC to TCT. So in 2022, the applicant, or excuse me, TCT began working diligently with FSEC staff to determine and decide whether to file both the transfer request and the amendment request. So next slide, please. So here's the thing. Here's the thing that's really, really important to us in understanding where we're at. It was not until 2018 that the appeals of all the state and federal permits were exhausted. So the essential reason for the latitude for construction in the FSEC rules is that frankly, no project facing fierce multi-year litigation can secure financing, can proceed until appeals are exhausted that would actually jeopardize construction of a project. No prudent developer would proceed under those circumstances. And it is that fundamental risk that stops projects during appeals, which I think was calculated here, including appeals that have little or no merit. Next slide, please. All right. So Rissing, and I am largely reading these slides. I hate doing that, but I just want to make sure that I'm being very precise. So that's what I'm going to do. So I appreciate your patience. So the effective date of the site certificate agreement occurred at the time that the two parties, both the governor and the applicant, had executed the site certificate agreement. The term of the construction commenced 10 years after the effective date of the site certificate agreement. So that date is key to understanding where the project is now. So subject to conditions of the certification agreement, construction can start at any time within 10 years of the effective date of the site certificate. And very importantly, Site Certificate Agreement Article 1B states, this site certification agreement authorizes the certificate holder to construct the project such that substantial completion is achieved no later than 10 years from all final state and federal permits necessary to construct and operate, sorry for the typo, the project are obtained and associated appeals have been exhausted. And appeals in this matter were not exhausted until 2018. Next slide. So this is the rule for request for extension of the site certificate. Upon a request to extend the term of the site certification agreement, the council may conduct a review consistent with the requirements of the WACs that those of you who are in the room here can see, and other applicable legal requirements. So that is the right that we have on our view of an unexpired site certificate to conduct review and seek an amendment. Next slide. So the request for amendment. This is where we are now. The council shall hold one or more public hearing sessions upon the request for amendment at times and places determined by the council. Next slide. All right, amendment review. In reviewing any proposed amendment, the council shall consider whether the proposal is consistent with the intention of the original site certificate agreement, applicable laws and rules, public health, safety, and welfare, and the provisions which concern site restoration. So that's what ties the request for amendment to the transfer request. Next slide. So Whistling Ridge proposes, this is what we're asking for. Whistling Ridge proposes to update natural resource studies, including season-specific data and new visual simulations and other natural resource reviews and studies, including key viewing areas with within the Columbia River Gorge Scenic Area. Now that was done previously with the environmental impact statement. So we are asking the opportunity to come back in with an amendment that gives us the time to evaluate these resources and make a final determination on moving forward. We only asked for a 3-year extension because we did not wish to draw this out, and we want the opportunity to move forward with an authorized facility in hand. All right, so next slide, please. I'm sorry for those of you out there who probably can't see this slide, but the following slides here, matters to be addressed in the amendment to the ASC, are in the filing, the petition for extension filing. That is a matter of public record, and you can find these documents easily, especially through Mr. Baker. So our intention, and we put timelines on these milestones to move the project along, is to conduct baseline environmental work, contact wildlife consultants, develop scopes of work, and move forward on a current evaluation of the project and what changes might be needed and what studies might be required. Next slide, please. Visual simulation updates. We clearly understand that to move this project forward, it will be necessary to undertake these studies to freshen them up and to have a full evaluation of the potential impacts to the project that may have, and issues that may have changed since the issuance of the final environmental impact statement. Next slide. Noise studies I talked about. Next slide. So we are proposing to complete all study work needed for the site certificate and develop a schedule to complete that work needed for the site certificate. Next slide. We've listed here agency meetings that we intend to undertake, involvement with FSEC staff and members of the public, and we would propose undertaking those studies for approximately 20 months after the transfer approval has been hopefully issued by the council. Next slide. This summarizes the studies and the process that we would anticipate to move forward should the council authorize the extension. Next slide. All right. I want to just take a moment here to talk about specifically the effective date issue. And so I'm going to walk through this as quickly as I can. So on March 5th of 2012, as we indicated, Governor Gregoire signed the site certificate agreement. And by law, under the definitions in RCW 80.50.020, a site certification agreement is a binding contract. It's an agreement. It's a binding contract. It's not a blend of a contract and a permit. It's a contract. So the effective date, Whistling Ridge signed the site certificate, final effective date of the site certificate agreement. The concern for ongoing litigation caused delay in executing the contract. The FSEC web page itself states that the effective date is November 18, 2013. And that is the date. This is actually noted on the web page and handwritten on the face of the March 5th, 2012 letter from Governor Gregoire. So it is a matter of public record, both from confirming the 5-year reporting and based upon what the site certificate itself says that that the effective date is November 18, 2013. So certification means a binding agreement under RCW 8050.020, a binding agreement between the applicant and the state, which embodies compliance with siting guidelines in effect as of the date of the certification, which have been adopted pursuant to RCW 8050.040, as may be further amended. Litigation was in fact filed and pursued for years with this project. The Ninth Circuit Court of Appeals litigation was only resolved in July of 2018. Litigation existed and occurred from 2011 to 2018, and 2018 was when the appeals were finally concluded. The effective date of the site certificate is November 18, 2018, and that, as testified by Jason Spadaro at the 5-year hearing, quote, "That was the date I executed the site certificate agreement after conclusion of the Supreme Court appeal. Further opposition litigation followed the execution of the SCA, with the Ninth Circuit Court of Appeals challenges fully exhausted in July of that year. Due to the uncertainties associated with the appeals, it simply wasn't possible to move forward with the project at that time." So there was no dispute by the city, the siting council at the 5-year meeting on the effective date of the facility. So speeding up to where we are now, wrap this up quickly. On March 2nd, 2022, TCT filed a request for extension to the site certificate with FSEC, seeking a 3-year extension from the date the request would be granted. We worked with Siting Council staff from that point forward to discuss and evaluate how we would proceed, if we should proceed, and what kind of a filing we would make. So on March 16, 2022, a letter from Twin Creeks Timber formally notified Ms. Bumpus that TCT had acquired the project as part of a larger acquisition that occurred in November of 21. April of 23, another letter to Ms. Bumpus that attached a draft transfer request for discussion with FSEC staff. So in September 13, 2023, Whistling Ridge filed its formal request, We had already filed a request, but we filed a formal request that we asked be sent forward to the Siting Council for review. Many of you know what happened during the City Council in the autumn of last year. We were all very much underwater with the Horse Heaven project, and staff preferred that we schedule the hearing at a later date due to the time needed for FSEC to complete that project's review, including adjudication and the SEPA process. TCT didn't object to that request, and we deferred to FSEC on scheduling. It was understood that further activity on the project was stayed at the date that we filed the request for extension in 2022. That means that there's actually still time on the site certificate agreement, and we have provided information in the petition itself stating that. So we concurred with staff that staying the request until FSEC had the capacity to review the project was acceptable, principally allowing completion of the adjudication that occurred through the fall. So all told, the appeals took 6 years to resolve. And by contract and by equity, we believe that technically we probably actually have 4 additional years to construct the project due to the protracted appeals. However, rather than relying solely on Site Certificate Agreement Article 1B that I read earlier, staying the exhaustion of all state and federal appeals, we seek a formal extension rather than risking further litigation by relying on our luck in staying the appeals and drawing further litigation on that strategy. I do want to say that this is obviously a challenging project. A number of us have a lot of skin in this one. We went through a lot of battles to get to where we are, and we believe that this project has the capability of being successful and proceeding, particularly with fresh review, which is what we're asking for. We are simply asking for the time to complete this, and we believe that we are fully entitled by right to a project that still is within its effective date. That's a lot. I'm sure some are confused, but that is where we are with this project, and I do appreciate your time.
Thank you.
Thank you.
All right, this is Judge Bradley. Chair Drew, is it now time to move on to the public comment section?
Yes. Thank you.
All right. And Ms. Grantham, who is our first speaker?
The first speaker we have is Nathan Baker.
All right. And Mr. Baker, please spell your first and last name for the record, please.
Thank you, Nathan, N-A-T-H-A-N, Baker, B-A-K-E-R.
Thank you. You may proceed.
Thank you. For the record, this is Nathan Baker, Senior Staff Attorney with Friends of the Columbia Gorge. And because this is a different hearing, I just want to note that regarding our process objections, more than 900 people on FSEC's official list of people interested in the Whistling Ridge project have not been notified about the pending matters or these hearings. So I'd like to reiterate and expand on the expiration issues, because it truly is a threshold dispositive issue. It resolves everything. The site certification agreement has expired. There are two possible dates that apply here, and it's expired under both of them. A site certification agreement absolutely is both a permit and a contract. And the applicable law, in the sense that it's a permit, the applicable law uses terms like the issuance date, the effective date, and the approval date. When Governor Gregoire issued the site certification agreement on March 5th, 2012, she signed a two-page statement approving the site certification agreement. And she used that word. She said she was approving it. So in that sense, it is a permit. She also, again, indicated right above her signature that the site certification agreement was effective on March 5th, 2012. She used that word, effective. That was the effective date. The other date that has been discussed was November 18th, 2013. That was the date that Jason Spadero, president of Whistling Ridge Energy, signed the site certification agreement. He withheld his signature for 20 months. When he signed it, that was the last possible date for the binding date or the execution date, in the sense that the site certification agreement is a contract. And again, the applicable law uses those terms, the words binding and execution. It is now more than 10 years after both of those dates. It's expired under both concepts. It's expired as a permit, it's expired as a contract. After the last time that Whistling Ridge Energy was before you was November 2018. That was what they call their 5-year update. It was actually nearly 2 years late. It was due December 2016. They were in front of you November 2018. After that, 3 years and 4 months went by with nary a word about Whistling Ridge at all at any of the council meetings. No updates, nothing. And then suddenly in April 2022, a month after the site certification agreement expired, it came back. And several council members were very astutely picking up on that something is really wrong here. Councilmember Young used the word mothballed, and he asked, why has this matter been mothballed for so long? Chair Drew pointed out that the litigation had been resolved in 2018 and that nothing had happened since then. Councilmember Kelly remembered that another matter had expired, the site certification agreement had expired 10 years after the issuance, and wondered why didn't that happen here, and wondered what's different about this one. I'm not sure which other project she was referring to, but she was right. That was the exact way of looking at it. And that's what happened here. The site certification agreement has expired both as a permit and as a contract. I was surprised to hear Mr. McMahon point to a provision of the site certification agreement that says that the 10 years doesn't begin to run until all permits have been obtained and any appeals thereof have been exhausted. That's ridiculous. That would mean that the 10 years hasn't yet started because they haven't gotten all their permits, for example, forest practice conversion permits. But you don't have to worry about that because it says in the site certification agreement that FSEC's rules preempt and supersede the provisions of the SCA. What we ask the council to do is to do the same thing that it has done in past matters, including the Cowlitz Cogeneration Plant project in 2004. Adopt a resolution confirming that the site certification agreement has expired by operation of law and by its own terms. That's the only possible outcome here. But it's also the right thing to do. It's the quick and easy way to end these proceedings, and it will moot everything else. Thank you.
All right, thank you. Next on our list, Ms. Grantham.
Next, I have Rick Arambaru.
And Mr. Arambaru, are you there?
I am here. Yes, indeed.
All right, and please spell your first and last name for the record.
First name is Rick, R-I-C-K, and last name is Arambaru, A-R-A-M-B-U-R-U, and I'm here tonight representing SOSA, Save Our Scenic Area. And as indicated previously, I've been involved in this project for at least 15 years. And as a part of that, I did listen to Tim's comments tonight, but he didn't mention what he told the FSIC council in October of 2011, almost 12 years ago, when he objected to the council's decision to remove certain turbines. And he said, and I'm quoting here, "In fact, extensive testimony in the record evidences that the recommended project is likely not economically viable. The A1-A7 turbine corridor has a robust wind resource, and eliminating it and the C1, C8 turbine corridor kills the project. Kills the project." He's never indicated any of those statements were incorrect. The project has died of its own weight, and did so 12 years ago. Now, there's an indication here that one of the reasons we need the extension is to do more economic investigation. But the record shows, and my letter to you, shows that the MET data, the economic data for this project has been studied in detail since 2003, more than 20 years. Pacific Core looked at the project, passed on it in 2003. PSE, the state's biggest IOU, looked at the project in 2008, passed on it. And SDS has now passed on the project. It's not a viable project, and I'm disappointed, Mr. McMahon, not to admit that. So the project, while he says that we're going to develop the project as it is presently stated, the one that's dead and has been killed by the council, one of the jobs that they're going to undertake is develop a schedule to complete the site certificate amendment application. They know that they're not going to move forward with this. They have to amend the site certificate application to bring this anything close to an economic project. And the simple answer here is just to start over. That's the appropriate thing to do. We look back at, and I listened carefully to the council's deliberations on the Desert Claim project. And there was an extension request by them, but the council carefully noted that that was a shovel-ready project, that the work had been done. There wasn't any changes in the project that were necessary, but the applicant there was lacking a power purchase agreement with the utility and needed some more time to work that out. There wasn't any changes in the project that were going to be undertaken, no further review, and the council appropriately approved that. But that's not the case here. This applicant says that they have to conduct economic evaluation, meteorological evaluation, resource evaluation, when in fact all of those issues have been studied to death. TCT is hoping at some time in the future for a Hail Mary, for the sun to rise and set on their project, and so that they will get lucky with something in the future. It is not and should not be the business of the council to engage in such speculation on projects. Nothing stops TCT from filing a new application with this council. And finally, one additional comment, and I certainly adopt Nathan's comments and other comments about the expiration of the site certificate agreement. But as indicated in my prior comments, the site certificate agreement terminated by its own course when SDS, the timber company, liquidated its holdings, including this project, sold it without submitting an application to this council. And that happened in September of 2021, and the project at that point had expired. The council, it seems to me, appropriately should deny the request for extension without prejudice to the applicant moving forward with a new application, new data, new information that can be developed over a period of time, subject to new adjudication and review. Thank you very much for your attention. Council members, if you have questions for me, I'm happy to answer them.
Thank you, Mr. Aramburu. Ms. Grantham, our next speaker, please.
Next is Vince Reddy.
All right, and Mr. Reddy, can you hear me?
I can.
And again, please spell your first and last name, and then you may proceed.
Sure, it's Vince Reddy, VinceReady.
Thank you.
All right, so thank you. I appreciate the opportunity to provide comments here this evening. As I said, my name is Vince Reddy. I live in the heart of the Columbia River Gorge National Scenic Area, and I want to just restate this for the record since it's a separate matter. My home is located less than 2 miles from the proposed site of the Whistling Ridge Energy Project. I can see the ridgeline where these wind towers would go up when I look out my window. So this is deeply personal and very important to me. I'm here this evening as a concerned citizen to provide comments on the requested extension of the state-issued permit for this project. I gave public comments on the Whistling Ridge project prior to the issuance of its original site certification and have been a strong opponent of this project ever since. The Whistling Ridge site certification ceased to be viable when it expired on March 5th, 2022. As others have already stated, there is no plausible or credible basis to assert that the SCA is still valid. The permit and contract should be seen as effectively terminated by the force of law purely on the basis of the passage of time. And it has been over 2 years since it expired. That expired certificate was issued over a decade ago, and much has changed since then. Part of the reason that site certificates are time-bound and finite is that leaving it open-ended doesn't allow for reevaluation of the project by the then current council and the current environmental guidelines and regulations, and with the input of the public who may not have been involved or affected 12 years ago when this first came about. So if anything is to move forward, it needs to start from the beginning with a fresh look. Mr. McMahon stated that the Siting Council has the sole discretion to make this decision, but there is no need for discretion here. The status of this permit is clear. By every conceivable definition or measure, it has expired, and it has been for over 2 years. The council should adhere to the rules and deny both of the requests on the agenda this evening. There has been strong opposition from the community members ever since this project was initially proposed by people who care about protecting the national scenic beauty of the Columbia Gorge. And unfortunately, the short notice for the hearing this evening and the lack of timely notice to interested parties who registered with FSEC means that some people who would be here tonight probably are not to provide comments at this evening's proceedings. The environmental impact studies are stale and out of date. So everything that underpins the original SCA needs a fresh look. Granting an extension would bypass the appropriate reevaluation processes that would happen if the applicant were to submit a new application for the project. I would also like to add that it should not matter whether the applicant does or does not intend to make material changes to the design and the scope of the project. The permit is expired, and any new development should be undertaken through a new application process. Rather than conducting updated environmental or visual impact studies voluntarily, as was mentioned, the applicant should be held to the normal review and decision-making process of any other new development project. The most important thing that I want to emphasize tonight is that the site certification agreement is expired, and that means that it has ceased to be valid and can no longer be considered for either a transfer or an extension. So I urge the council to uphold your duty to confirm the expiration of the site certificate and disallow this request for an unmerited transfer, renewal, or extension. Thank you.
All right, thank you. Ms. Grantham, our next speaker.
Next is Brian Telligen.
Okay, Mr. Telligen, can you hear me?
Yes, can you hear me, Judge Bradley?
Yes, I can. Can you please spell your first and last name for the record, please?
Yes, Brian, B-R-Y-A-N, Telligen, T-E-L-E-G-I-N.
Thank you, and you can proceed with your comments.
Thank you, Judge Bradley. I represent, again, Friends of the Columbia Gorge. And again, I'm going to be speaking on the SEPA issue, as I did in the transfer request hearing. When Friends of the Columbia Gorge submitted their objections to the hearing process, like with the transfer application, we argued that the extension request is an action that requires SEPA review. And the underlying premise, I think, is pretty intuitive. The project can't move forward unless the SCA is extended. You're therefore allowing this project to go forward when it otherwise couldn't. That's an action that needs to be evaluated under SEPA. Mr. McMahon, in his response to that objection, said, sort of echoing what he said here, that that's not the case. And the rationale that he cited was that the SCA extension is categorically exempt. And he specifically cited WAC 197-11-800, subsection 17. And that is a categorical exemption that basically allows what's refers to as basic data collection and research. The idea is that if all you're doing is studying the environment, you don't need to undergo SEPA review, right? It's only when you're seeking approval to modify the environment do you have to undergo SEPA review. You don't need SEPA review just to perform various studies. And that's what Mr. McMahon was here again today saying, that, you know, they want to extend the SCA so they can do a bunch of studies on wildlife, visual impacts, all sorts of things for a project that they have, a new project that they have admitted in their pleadings before you will require a supplemental environmental impact statement that you won't be able to rely upon the old one. And frankly, we agree with Mr. McMahon that he doesn't need, and his client doesn't need, the applicant doesn't need to do SEPA review to go out and do a bunch of studies, to engage in, you know, conceptually coming up with a new project. He doesn't need to do SEPA review for any of that. He also doesn't need an extension to do any of that. He and his client can go out and study the environment and do all the visual impact studies they want. They can study birds and impacts on wildlife and cutting down trees and whatever else they want to study. None of that requires either SEPA or an SCA extension. What he wants to do, and what the applicant wants to do, is keep this dead project alive so they can come up with a different project. That's the plan, is to go and study and keep this one alive to come up with a new one. But that strategy requires the SCA to be extended, which means it requires an affirmative decision by the council giving them the right to build this project over the next 3 years, the one that we're talking about right now. And that is giving them authority, if they so choose, to build this particular project. That is an action. He doesn't need it to do studies, but that's what he's asking for. And so the thing he's actually asking for does require SEPA review, which must be undertaken before the council or the agency as a whole were to take any action on this proposal. But I guess I'd just like to say, you know, not only is this a dead project, and not only is the SCA expired, the irony is that the applicant doesn't even need what they're asking for. They don't need to do any of it. They can just go out there, come up with a new project, do all their studies, and come back and seek approval for a project which they openly admit will require a new supplemental environmental impact study. So I would ask, first of all, again, reiterating that the council should just take the simple, logical, legal path forward and adopt a resolution recognizing that the SCA is already expired. But if not, then you need to take seriously what the applicant is asking for, and that is the right to build a project that they don't have right now. And that requires the agency to go back and think about whether the old 13-year-old FEIS is still adequate, what needs to be done. It's a complicated matter, and it requires more than Mr. McMahon's say-so, that there are no change conditions or new information. The agency itself actually has to evaluate that issue, make a SEPA threshold determination. So thank you very much.
Thank you. Our next speaker, Ms. Grantham.
The next speaker is Sean Smallwood.
Okay.
Hello. Oh, I'm sorry.
That's okay. Mr. Smallwood, could you spell your first and last name, please?
Will do. My name is Sean, S-H-A-W-N, Smallwood, S-M-A-L-L-W-O-O-D.
Thank you, and you can proceed with your comments.
Thank you. I worked on issues of wind and wildlife for 25 years, having performed research into the issues of the Altamont Pass Wind Resource Area, which is the world's most notorious wind resource area regarding impacts to wildlife. I also served on the Scientific Review Committee that was tasked with more accurately estimating collision mortality and with finding solutions to problems in the Altamont Pass. I'm addressing you today because I was retained as an expert witness by Friends of the Columbia Gorge and Save Our Scenic Area, who asked me to review the proposed extension request for Whistling Ridge. I'm going to highlight what appears in my written declaration, which you are welcome to review for more details. It has been submitted. Regardless of whether the project is built as approved in 2012 or with taller wind turbines, the project would result in significant impacts to birds and bats and other wildlife. Based on wildlife collision mortality data from other forested wind energy projects in the United States, I predict Whistling Ridge would kill 29 birds and 69 bats per megawatt per year. For perspective, these fatality rates would exceed those of the notorious Altamont Pass by 33% for birds and by more than 12-fold for bats. I will also note that up through 2012, we didn't have mortality estimates from forested environments. Now we do. If the project is built to 75 megawatts as proposed, it would destroy nearly 2,200 birds and 5,200 bats per year. Many of these fatalities would be members of special status species, and many would leave chicks on the nest and young dependent bats in the roost. In other words, the impact would be much greater than the numbers we often banty about. These losses would be important ecologically, economically, and culturally. The environmental review of information that contributed to 2012 approval was, frankly, flawed at the time, but now is grossly outdated. The metric of collision mortality at Whistling Ridge has since been found to have been plagued by insufficient survey effort and by substantial biases due to poor implementation of carcass detection trials used to estimate the number of fatalities that are not found during routine fatality searches. Metrics of predictor variables such as the use rates and the exposure index, which appear in the earlier project documentation, have since been found to be unpredictive of collision mortality. They have nothing to do with it. Patterns of behavior are more predictive. Our study methods and technologies have advanced considerably since 2012. For example, these days we use thermal imaging to see nocturnal activity of bats and birds, and we use scent detection dogs to search for fatalities, which are much more effective than human searchers, which is the old method of doing searches. With larger turbines on taller towers, more bats and nocturnally migratory songbirds are likely to be killed. And there must be more construction grading to accommodate the larger turbines, hence more habitat loss. Based on my experience working in the Altamont Pass, the project would industrialize the project site, increase the frequency of fires, and reduce the abundance and diversity of wildlife. These outcomes would be contrary to protecting public health, safety, and welfare. To protect public health, safety, and welfare, I recommend updated and supplemental analyses of potential project impacts and not relying on the old documentation. I suggest that a reasonable alternative to the requested extension is to require Whistling Ridge Energy to submit a new application for a new site certification agreement. This way, the appropriate data can be collected and analyzed using modern methods to more accurately predict potential impacts and to appropriately formulate mitigation measures It would also help to seat a committee of qualified experts to assist with these steps going forward. The committee of this nature worked very well in the Altamont Pass and should be used on a project like this. Thank you.
All right, thank you. Our next speaker, Ms. Grantham.
Next, I have Eric Kloster.
All right, Mr. Kloster, please spell your first and last name.
Hello, my name is Eric Kloster, ERICKLOSTR.
Thank you, and you can proceed.
Thank you. I'd like to make a small correction from the last public comment that I made on the transfer. I had said that the western gray squirrel was not extant within Skamania County, but upon further review of Sean Smallwood's document, it says that they're likely in the area. So in addition to being in Klickitat County, it appears that they're likely on site as well. So in addition to the northern spotted owl, there's another state endangered species that we should be concerned about within the site. Additionally, I'd like to mention that no one has brought up indigenous sites or potential indigenous issues with this region. I know with Horse Heaven, the council liaisoned with the Yakima tribe, but I haven't seen any evidence of that here in this case. Moving on to more legal issues, though, FSEC should discourage unlimited build windows for sites. Whistling Ridge Energy should file a new application for a permit rather than asking for a transfer or an extension, whether that is done by Whistling Ridge Energy or by TCT. I would also like to bring up that the effective date that the permit was ended was March 5th, 2012, which is 10 years after the beginning of the permit, which was signed by the governor in 2012. The binding date also has expired. That was expired November 18th, 2023. I would like to mention that in addition to not being able to transfer the site, Whistling Ridge Energy cannot extend an invalid permit. FSEC cannot legally extend a permit which does not currently exist. And this is a dispositive issue. This issue is a legal issue. And unfortunately for Whistling Ridge Energy, the council lacks the authority to amend a site certification agreement that has expired. In the Cowlitz Generation Project in 2004, the council declined an extension and said that the project had died of its own accord. To quote Alan Fiskell from the FSEC manager at the meetings for the February 17th, 2004 FSEC meetings, he said, quote, "So I think at the next meeting, what we propose is that council have some resolution memorializing that the SCA died of its own accord and officially render it under. Here, FSEC should similarly render this issue under. This issue has expired both under the effective date and the binding date. In addition to the problems with the western gray squirrel, which is likely within this area and has recently been uplisted, and the emphasis area being set for the northern spotted owl, which is a federally listed species as endangered. The FSEC Council should legally declare, and they must, that the site certification agreement has expired per the agreement and legally according to the statutory rules. Here, Western Ridge Energy asked the FSEC Council to perform a revivification miracle. But unlike the resurrection of Lazarus in Bethany, this is a sickness unto death. Thank you very much.
Thank you. Ms. Grantham, our next speaker.
Next is Dean Apostle.
Mr. Apostle, can you spell your first and last name for the record, please?
Yeah, can you hear me okay?
Yes, thank you.
Great. Dean Apostle, Dean Apostol. And
Thank you.
I live in Damascus, Oregon. I'm a semi-retired landscape architect and natural resource consultant and visual resource expert. I've been asked to help on this project by Friends of the Columbia Gorge and I think it's called Save Our Scenic Area. And so I'm going to provide a little bit of review just on the scenic issues only. In my opinion, the project will likely result in significant impacts to scenic resources, and that's regardless of whether the project is built as approved in 2012 or whether, as is more likely, there's a revised application with larger wind turbines. Wind turbine size has increased quite a bit since 2012. I think 56% on average. And so it's hard to believe they would move forward with the project with the smaller turbines that people were building in 2012. So you've got to assume they're probably going to have larger turbines. The visual impact analysis from the prior approval, which was for smaller turbines, is flawed and incomplete. There's new experience and techniques with analysis of visual impacts from wind facilities. A lot has happened since 2011. We have much better simulation techniques and standards, and much better visibility mapping than we had back then. The site conditions are probably quite a bit different now than they were in 2011. That's a forested area, and trees grow pretty fast in this part of the world. Douglas fir trees grow 3 feet a year. So I don't know, in comparison, it probably looks quite a bit different than it did 12 or 13 years ago. View distances from the key viewing areas in the Columbia Gorge to the project are only 1 to 8 miles. And there's a paper by Robert Sullivan of the Argonne Lab that came out in 2012, just after this project was approved, that looked at visibility of turbines from varying distances. And they were trying to determine visibility of turbines and dominance. And what Robert Sullivan in this paper found was that turbines are clearly visible in Western landscapes at distances of up to 36 miles. Blade movement can be detected at 24 miles, and turbines are visually dominant typically at 12 miles. So we're looking at view distances of 1 to 8 miles. We can expect visual dominance at 12 miles, and visual dominance is where you start to get into large impacts on scenery, is when you have a dominant element. The turbine sizes, like I said, were smaller than they probably would be today. That would increase, larger turbines would increase visibility. Taller turbines are seen from farther away, and they're seen from more places because they're not hidden by the terrain like smaller turbines can be. So visual analysis, you have key viewpoints that have high sensitivity. You have visual dominance of the project. You're going to have high impacts. And I just think that FSEC should realize that things have changed. Systems of analysis are much better, and allowing this project to just kind of go ahead with some kind of minimal analysis is, I think, highly risky. I've been involved in a project over in Horse Heaven Hills. I think some of you probably heard me testify on that one. And I believe that in that one, the proposed turbines are 411 feet to the hub and up to 670 feet to the blade tip. So that's much bigger turbines than what we have had in 2011 or 2012. And that's all I have to say. Just a note of caution about moving ahead with this project without requiring better and more detailed analysis. Thank you.
Thank you. Ms. Grantham, who is our next speaker?
Next, we have Dan Raleigh, and I know that he is on the phone, but it shows he is muted. So, Mr. Raleigh, if you are trying to unmute, you can use #6 or *6.
Are you there, Mr. Rowley?
Can you hear me?
Yes, thank you. Can you spell your
Okay.
first and last name, please?
Daniel Raleigh, D-A-N-I-E-L, Raleigh, R-A-W-L-E-Y. I live on Underwood Mountain, and like one of the previous speakers, I can look out my window and see where the project was going to be. So it has a direct impact on myself as well as pretty much anybody that would live on Underwood Mountain. Before I bring up some other points, I do want to make the issue that I don't think that the interested parties were properly informed. I've been doing a lot of calling myself, and since I found out that this project was being, I guess, brought back to life, and most people didn't really or hadn't heard of it. So I'm concerned that the proper notifications weren't made, and that is an issue that I would like on the record. As previously noted by Nathan Baker, whether you pick the date of March 5th, 2022 or November 18th, 2023, the site certification agreement is expired. So this really makes this project dead on arrival. So I'm not sure why we're even discussing the process of an extension of something that that is already dead. And I'm very concerned that this is even being brought up. I know Mr. McMahon was able to, I guess I would call it spin the dates quite well, almost made me feel like going to law school. Not really, but I want it, when you have a contract, it's a binding contract, and it should be upheld. And I think that I urge the council to deny the permit and transfer, as well as any extension, which shouldn't actually be considered. If they're really serious about this project, I think that they should apply a new application, because previously this project was financially not viable. And to make it viable, they're going to have to change some of the, they're going to have to modify the project, whether that be, as previously noted, with taller windmills, different blades, different profiles, and that's going to significantly change the impact on the environment. And if they really are trying to make this work, a new application process should be done. So I appreciate you taking my comments tonight. Thank you.
Thank you. Our next speaker, Ms. Grantham.
Next is Mary Ripar.
All right, are you there, Ms. Ripar?
Oh, I am. Thank you. Sorry, too many mute buttons here. Can you hear me?
Yes, I can. Can you spell your first and last name, please?
My name is Mary, M-A-R-Y, Ripar, R-E-P-A-R. I live in Stevenson, Washington. And many years ago, I was involved in this project. It's almost 15 years for me, because we started the project with the DEIS and then the FEIS, of course. And I am many moons older. I had my 72nd birthday just a few days back, and my hair is a lot grayer. And as many of you know, none of us get younger, and neither do projects. projects get old, their data gets stale, and eventually they have to be buried and staked and new ideas be birthed. So I urge you all to put paid to this project once and for all. I have 2 boxes of data upstairs in my attic about this project. I would like to eventually, before I pass this mortal coil, get rid of them and not have to worry about them being resurrected. So I oppose the transfer, and I oppose the extension of the SCA's expiration date to November 2026. It is time to let this project go. When SDS was liquidated, this project should have been liquidated with it, the permit at any rate, and the site certificate also. Projects have a due date for a reason. New technologies come along, new environmental rules and regulations come along, and they're not getting easier. They're getting tougher and tougher because we have now a new thing 12 years, 15 years later called climate change, especially in the gorge where fire danger is even greater today than it was 15 years ago. So I urge you all to deny this request. It's just time to get past it. I really do not think that an organization that we know nothing about comes in and asks for the site certificate to be extended, and we don't know their qualifications and why they're actually doing this. If you want to do a project, start from scratch, and I'll show up. I'll just be grayer when I do. But I really think that some of the information that I sent to you in my letter about old NEPAs, which is what they're called, even though this was a SEPA, the NEPA information, or NEPA, SEPA, the environmental information still is relevant. And if the if NEPA thinks that DEISs and FEISs get old, then I think FSEC should too. Things get aged, they need to be renewed, and this permit and the SCA need to finally have a death. So it is very troubling to me that Twin Creeks is doing this now. There was a lot of time for them to do it when they first started looking at SDS, and SDS could have done something, but this project is not feasible, it is not economic, and it is environmentally dangerous for our national scenic area and for the entire gorge. There are new technologies coming that will help us with our energy, and having bigger turbines is just not it. And I just put something, I know you're not taking, this is not an environmental review. However, something that came up in my research was the fact about the impact of taller turbines on airplanes. And as you know, we have contrails, like 15 of them during the summer, coming over our area. We have the PDX National Guard folks going up and down the river to the range, military range down upstream. And there are effects. I've included the documentation from the Department of Defense in my filing, and I hope that gets into the record. So thank you very much for holding these hearings, and please deny the site certification agreement extension and also the transfer. It is time for this project to die a timely death, and we can move on with our lives. Too many hours and years have been dedicated to this permit already. Thank you very much.
All right, thank you. Ms. Grantham, our next speaker.
Next, I have Steve McCoy.
All right, Mr. McCoy, can you hear me?
Yes, can you hear me?
Yes. Can you spell your first and last name for the record, please?
Sure. Let's go with Stephen, Steven, McCoy, McCoy.
Thank you. You may proceed.
Good evening, Chair Drew and members of the council. Again, I am Steve McCoy, representing Friends of the Columbia Gorge. As you've heard from others tonight, the Whistling Ridge SCA expired by operation of law on March 5th, 2022. Council should confirm the expiration of the SCA, which moots all other issues. However, if the council declines to confirm that the SCA has expired, the council should deny the extension request on the merits, especially since WRE has from the very start in 2012 publicly and candidly disclosed that it has never intended to build and operate the project as approved by the governor in 2012. FSEC has long had a policy against allowing projects with unlimited build windows to remain on the books indefinitely. In fact, in deciding a recent case based upon a similar set of facts, the council held that, and I'm quoting the council resolution on Grace Harbor here, an unlimited build window for a proposed project is not appropriate as over time, technology or mitigation measures presented in an application may no longer be protective of environmental standards and conditions at the time the facility is constructed, end quote. In the Grace Harbor decision as here, the applicant sought an extension of the SCA term while stating that there was not sufficient demand to construct the facility at the time. The council determined that based upon the applicant's request for more time for a project that was not currently economically viable, the applicant was in effect seeking an unlimited build window, and the council accordingly denied the amendment request. An unlimited build window for a project that is not feasible is exactly what WRE is attempting to get here. In its petition for reconsideration filed with FSEC in 2011, even before the 10-year term of the SCA began, WRE emphatically claimed that the reduction from 50 to 35 wind turbines rendered the entire Whistling Ridge project economically unviable. This included the following statements from WRE. The recommended project likely is not economically viable. The council's decision to eliminate specific turbine strings kills the project. The approved wind turbine facility would be unlikely to offset project development costs. And they concluded by stating that an economically unviable project is no project. They were also candid in the press that the project is unviable, and you can look to our written comments for some quotes. In fact, there's been so little activity on the project that in 2022, the council had to be briefed on what the project proposal was, because it had been inactive for so long. That led Councilor Young to ask if the project had been mothballed for 11 years, and Chair Drew to ask if there had been any further activity on the project. Staff replied that there had been no further activity either before or after any appeals were resolved. Today, the proposed project is no less mothballed than it was 2 years ago, and Friends' written testimony details how WRE's chronic delays do not seem like the actions of an entity that is reasonably moving toward project construction and completion. In addition, according to the agency's notes from a July 26, 2023 meeting between FSEC staff and WRE, WRE said it anticipates seeking yet another extension request to construct the project, even if the 4.66-year extension is granted. At the same time, WRE has not signed any power purchase agreements and does not have an interconnection agreement with the BPA. These inactions are not normal for an entity actively attempting to build a project, but are rather the actions of an entity that wants an unlimited build window. WRE currently admits that no on-the-ground work would occur in the next 3 years, even if the requested extension were granted. However, Friends asked the council to recognize that the project is not a real project, to determine that an unlimited build window for this economically unviable project is improper, and therefore to deny the extension request. Thank you for the opportunity to make these comments.
Thank you very much. Our next speaker, Ms. Grantham.
Next is Rudy Salakori.
All right.
Good evening. Can you hear
Good
me?
evening. Yes, I can hear you. Can you please spell your first and last name?
Of course. Rudy Salakori, R-U-D-Y, S-A-L-A-K-O-R-Y. Good
Thank
evening
you.
again. Oh, you're welcome. Once again, my name is Rudy Salacore. I'm the Conservation Director for Friends of the Columbia Gorge. I am a longtime resident of Washington State living in Vancouver, and I'm here speaking on my own behalf. As before, I will be brief. As you've heard repeatedly and through, as Nathan Baker had said earlier, voluminous script, we have been working on the Whistling Ridge Energy Project for decades. And we're curious again why, despite having 10 years to complete the project, it did not move forward. We heard a story about anticipating lawsuits, best business practices, but there were plenty of years remaining to begin implementing this project in earnest, far more time than they're asking for now. Again, I would like to take this opportunity to remind folks that this project permit has expired. We've approached that date and those dates in several different ways, but I think by any measure we can say that this permit has expired and should not be allowed to continue to be contemplated to move forward. More than a year after by any measure, at least more than a year after the permit has expired, we're seeing this mothballed project try to spring back to life. Not only is this inappropriate, but it has occurred without significant public involvement. To our knowledge, very few, if any, of the members of the public who signed up for updates on this project or who were on the mailing list for this project were given any notice of these proceedings or this effort. Friends staff have repeatedly asked FSEC to provide public notice of these procedures or processes, despite having nearly 8 months or more to do so. Good government requires transparency and an informed constituency. By and large, the community opposed this project decades ago and likely still does, but you have no way of knowing their feelings without public notice. Again, I'm going to say, I want to remind you that this project's permits expired more than 2 years ago and that proper public notice was not given, nor were many local residents informed that this proposal was attempting to come back to life. I'm asking you to confirm that this permit has expired and that any project proposed through this body follows the proper procedures for a new development. Secondly, I'm asking that this body takes the time to properly inform residents and interested parties of upcoming procedures as per your own guidelines. And finally, I want you to consider that the environmental review and FEIS was prepared well over 13 years ago, and a new study or supplemental EIS to take into consideration any design changes or any other changed circumstances is itself reason enough to deny any consideration of an extension of an expired permit. As another speaker had mentioned, climate change is an issue that we are wrapping our heads around more and more every day. Wildfire risks are extreme. Many folks can remember the Eagle Creek fire from not that long ago. And with a spate of wildfires, devastating wildfires caused by transmission and power lines, we should be cautious about building any new lines or infrastructure into these delicate and vulnerable hills. I think that's about as much of your time as I'm going to take up. Thank you for the opportunity to speak. Have a good evening.
Thank you. Our next speaker, Ms. Grantham.
Next is Keith Brown.
All right, Mr. Brown, can you hear me?
Yes, I can. Good
And
evening.
please, good evening. Please spell your first and last name.
My first name, Keith, Keith, Brown, Brown.
Thank you. You may proceed.
My wife and I were notified of these hearings on the transfer and extension only because last fall, we happened upon a small article about an October 2023 FSEC hearing on Whistling Ridge in the Skamania Pioneer newspaper. Although we have been intricately involved in all of the Whistling Ridge hearings and adjudicated procedures during 2009 through 2011, we had not been notified of the October 2023 hearing either by mail or email. We have the same physical and email addresses we had in 2009. We then contacted FSEC staff to find out how it was we were not notified, and were told to sign up again for notifications. What happened to our long-standing request to be notified about anything Whistling Ridge? Was it simply misplaced or disregarded? This creates a serious question. How many of the hundreds of concerned citizens that participated and commented on the Whistling Ridge proposal in 2009 through 2011 were not informed about this 2024 hearing on the requested permit transfer and time extension. Therefore, they have lost the opportunity to comment. FSEC staff should be ashamed for failing to notify all of the previously engaged and concerned citizenry, both by email and mail. These hearings do not meet the spirit nor the letter of what is required to ensure full citizen participation in the process. Whistling Ridge has failed in its attempt to construct industrial wind turbines in this location for going on 22 years. In 2002, Whistling Ridge requested from the Bonneville Power Administration a 70 megawatt generation interconnection to BPA's energy grid for a new wind energy project. In 2007, Whistling Ridge proposed to build up to 85 wind turbines, each of them up to 426 feet tall on prominent ridge lines near the town of White Salmon. In 2008, Skamania County proposed an industrial overlay zone throughout Skamania County, which would have allowed the construction of these wind turbines. Public hearings were held in numerous locations throughout the county, including in Millay and Underwood. We attended all of these hearings, and there was widespread and overwhelming opposition and concern about the environmental impacts. Despite these well-articulated concerns, Skamania County issued a SEPA determination of non-significance, which was appealed by several non-governmental and nonprofit organizations in October 2008. In February 2009, the hearings examiner reversed the determination of non-significance and required Skamania County to prepare an environmental impact statement. The county declined to conduct the EIS and directed the project proponent for Whistling Ridge to seek approval from FSEC. That is how it came to FSEC. And the permit has now expired. Quoting from our August 20th, 2010 comment letter to FSEC on the draft EIS, which is as true today as it was 14 years ago. This siting, if it occurs, will set a precedent with troubling and long-standing consequences for not only forested lands in Washington, but will also put at risk all other national and state treasures, parks, and scenic areas. Must we blindly go forward and ruin all that has been set aside? Once it is gone, it is gone. Employing wisdom and forethought, if there was ever a time for FSEC to determine, no, the cost is too great, this is it. In our letter, we provided you with a summary of all of the 1,390 FSEC written comments. 86% of those comments expressed concern or opposition. We urge you to take the appropriate action and deny the request to transfer the permit and extend the time frame for what is now an expired permit. This ill-conceived project has loomed over Underwood, Millay, White Salmon, Benjamin, Hood River, Mosier residents, and the Columbia National Scenic Area for 22 years. It's time to recognize it should be dead and buried once and for all. Thank you for your attention.
Thank you. Our next speaker, Ms. Grantham.
Next is Peter Cornelissen.
Okay. Mr. Cornelissen, can you hear me?
I can, yes. My name is Peter Cornelissen, P-E-T-E-R. Last name is C-O-R-N-E-L-I-S-O-N.
Thank you. You may proceed.
Dear Chairman Drew and members of the FSEC Council, I live in Hood River and I would have a view of the proposed Whistling Ridge energy turbines on ridges just north of our home. I've been opposed to this project since.
Sorry, Judge Bradley, he's cutting out. I'm not getting that down. I can't hear.
Yeah, Mr. Cornelissen, you're breaking up. Can you maybe stay in
I'll
one
try and get a little
place? Or...
closer. I'll try and get closer to the microphone. Is this better?
I think so. Go ahead.
Basically, if you didn't hear me, I live in Hood River, right across from the proposed project. I've been opposed to it since its inception, and I was very surprised to find out that there was a hearing on it tonight. I'm curious why I didn't receive adequate notice from FSAC. It seems to me that you have an obligation to notify people who've been involved in this project previously. I only found out about the hearing by chance, and I know that other people in the Columbia Gorge in both Oregon and Washington who have previously commented would very much like to weigh in on this project. I believe that this hearing without adequate public notice goes against public interest and fairness, and I'd like you to either consider holding it again. The thing that I prefer is actually you're denying the request for an extension of the site certificate agreement. It's obvious that it is expired by several years, and it's an obvious and direct violation of the law in your own terms. As many other speakers have said, I think you should instead require the applicant to start over again with a new application. And I also think that as a contract between the state of Washington and Whistling Ridge Energy, all rights under the Whistling Ridge SCA ceased no later than November 18th, 2023, 10 years after it was fully executed. So I think there's adequate reason to deny both of these requests. Thank you for letting me comment.
Thank you. Our next speaker, Ms. Grantham.
Our next one and the last person I have on this list is Dave Sharp.
All right, Mr. Sharp, can you hear me?
I can. Can you hear me?
Okay. Yes. Can you spell your first and last name, please?
Yes. My name is Dave Sharp, DAVESHARP. And I want to thank the council, thank Chair Drew and the council for the opportunity to speak. This represents a summary of my public comment. I will submit along with this some detailed comments about some of the items in the body of this comment. The applicant requests and intends to install larger turbines that have higher nameplate capacity. Although they say that the project may be the same project, make no mistake, the only way this project will be viable is to have larger turbines. The original application clearly identifies a range of turbine height, nameplate, and prior FSEC determination that established the maximum number of turbines allowed. An argument that larger turbines would result in equivalent or less impact to the environment per installed megawatt of nameplate is speculative and must be backed up with a supplemental EIS and analysis. The two major topics of concern are impact to viewshed and impact to avian species. Mr. Apostle and several other previous commenters talked about the viewshed, so I will not elaborate further. The second area, and one of most concern to me, is impact to avian species. The applicant used in the environmental impact statement an index to ascertain avian exposure. That index is a unitless comparative number. It does not represent a rate or an amount, and it should not be conflated with avian collision rates or avian fatalities. If the applicant intends to install larger turbines, and I believe they do, actual avian collision risk associated should use appropriate parameters such as a rotor swept area, operating hours per year, the blade cross-sectional area, load profile, and not this simplistic bird exposure index. These new turbine models that are now on the market are a whole different design than they were 10 or 12 years ago. They have huge rotor diameters with respect to the heights of the tower. They're meant to start operation with lower wind speeds, and lower wind speeds mean more operating hours, which means more impact to avian species. Then the larger rotor diameters also represent a larger area of exposure to the avian species. So we need to look at this from the standpoint of how many changes have been made to not just the turbines and not just their design philosophy, but to the laws. I mean, the Bald and Golden Eagle Protection Act has had some significant changes since the original SCA. And the Migratory Bird Protection Act is currently going through some other significant issues about the penalties and fines and fees. So we need to kind of step back and look at how FSEC approves these projects. The last major project constructed in Washington, which is the Skookumchuck Wind Project, included a collision risk analysis, and it used the U.S. Fish and Wildlife Service methodology. Whistling Ridge deserves no less. Unless a standardized method is used that is independent of contractors or consultants that are under the payment from the applicant, how can we trust the results? We need to make sure that the results, that there are results we can believe in. In conclusion, I want to say that if a collision risk modeling is performed using industry accepted collision models with larger turbines, I believe it will show that the risk to avian species, if anything, is greater per installed megawatt per year than the smaller turbines. Thank you very much.
All right, thank you. Ms. Grantham, has anyone else contacted you indicating they want to speak?
I have not received any additional messages or emails.
Okay, if there is anyone else who would like to speak at this time, you can raise your hand or you can unmute and identify yourself. I see a hand from Emily Schimmelfennig. I'm sorry, I'm probably not pronouncing your name correctly at all.
Actually, you did that very well. Yeah, that was perfect.
Could you spell your first and last name for the court reporter, please?
Yes. My name is Emily Schimmelfennig. That's E-M-I-L-Y. And then Schimmelfennig is S-C-H-I-M-E-L-P-F-E-N-I-G. I'm here tonight with Tim McMahon on behalf of Twin Creeks Timber and Whistling Ridge Energy. And I just wanted to briefly respond to, a few of the comments made tonight. We heard a lot about whether the SCA is expired and what that expiration date is. And, some said that the SCA has not one date, but two deadlines, or, it's a permit and it's a agreement. But here, there's really only one important date. Here, state law states that the certificate is a binding agreement between the applicant and the state. That's RCW 8050-26. There are also state law provisions that indicate the effect of a certificate, like the site certificate agreement. Those provisions state that construction and operation are subject only to the conditions set forth in the agreement. As Tim indicated, several provisions in the site certificate agreement provide that construction must be started 10 years from the effective date, or from the date of execution, I'm sorry, which is the date that both parties agree to bind themselves to the agreement. That date is November 18th, 2023. Now, there are provisions that could push that deadline out further, like the provision stating that it is 10 years after all permits are obtained and all appeals have been exhausted. And to the extent that TCT needs to go out and seek other permits, as mentioned by Mr. Baker, this deadline should only be extended further. But TCT actually took a conservative approach and filed its application prior to that 10-year deadline of November 18th, 2023. Now, another argument is that, even if the deadline was raised on November 18th, 2023, it's dead because now here we are in May 2024. But the applicant filed their application to extend the deadline of the agreement on September 13th, 2023, nearly 2 months prior to that November 18th deadline. And as is common in most proceedings, when a request is filed timely and prior to the deadline, passing the deadline while you're in the proceedings doesn't make that agreement invalid as a matter of law, even though now we're in May of 2024. And so I just wanted to highlight that there's an extension provision for a reason. It recognizes that there are unforeseen circumstances that may require some additional time, and that the one proposed by TCT is not long and unwieldy. It's 3 years, and it will allow for TCT to evaluate, environmental changes and all of the other things that have happened since the project was first issued in 2013. So we have this exemption process for this exact situation. And so, and that was all that I wanted to say. So please let me know if you have any questions. Thank you.
Thank you. Is there anyone else who wanted to speak? You can raise your hand or unmute and identify yourself. Not seeing or hearing from anyone else, so I'll turn it back to you, Chair Drew.
Thank you very much, Judge Bradley. Thank you for all of the information everyone has provided to us this evening in both these hearings. We will carefully consider all of the input, both through these hearings as well as what has been submitted to us about these amendment requests. And with that, have a good rest of your evening, and this meeting is adjourned.